Good morning, everyone. Can everyone hear me okay before I start? If you can just sort of give me a thumbs up or something to make sure we're all present and correct. Yeah, brilliant. A few going on. It's all very strange, isn't it, on webinars? Right, okay, well, I'll start now. If there's any issues, technical or otherwise, just please drop me a quick message and we can pick up on that. To introduce myself, my name is Sharon Auld. I am head of legal services at Neathouse Partners. We are a fixed fee employment law and health and safety consultancy manned by lawyers. So the purpose of today's webinar is to provide a brief overview of employment law changes and what has taken effect and what is due to take effect. I do say it with a caveat, however, that there is still a lot going on in the background in respect of the Employment Rights Bill. So we are going to continue with a webinar programme as soon as any issues and the government decide where we're going with it. So I can't categorically answer everything, but we'll give an overview and move on from there. So we're going to have a look at the Employment Rights Bill and the key changes, and more importantly, the changes and the effect that they have on you as businesses and business owners. It's getting things in place now so that we're all set to go no matter what goes through the legislation. So let's look firstly at flexible working changes. I'm assuming you're all up to date and you know that the changes have become effective. So as you can see from this slide, an employee is entitled now to make 2 requests in any 12-month period. Unfortunately, for employers, we used to be able to put a lot more emphasis on the employee to tell us what the impact on the business will be, and there was more flexibility in refusing or accepting a request. Now, unfortunately, the employee no longer has to explain what the requested change will have on the business and how it could be dealt with. So previously, they would have to say, I can do this flexible working because of ABC, i.e. I can do a job share or I can make up time elsewhere. They don't have to do that now. As employers, you have 2 months to make a decision, reduced from 3 months. So that's key for your policies and procedures. That needs to be updated. You're not permitted to refuse a request unless you have consulted with the employee. So again, you did that anyway, I'm assuming, under your policies that were previously relevant. You would have had a meeting with the employee, you would have considered it, you go back to them. It's now becoming more difficult, for want of a better word. Now, the Act does not introduce a day one right, but it is a day one right because the change was introduced by the Flexible Working Amendment Regs 2023, which came into force last April. So whilst the new Employment Rights Bill, etc., doesn't address this directly, you're all going to be fully aware that it is a day one right. If anyone has any burning questions on flexible working, that's I can pick that up. Another change, and this one is can be quite complicated. I'm not sure how many of you it would be relevant to, but it is really important that if it is relevant, you get your policy in place. It's introduced the Employment Allocation of Tips Act. That's really making it clear for everyone what it's concerning. So it introduced obligations to ensure that workers received tips, gratuities and service charges in full, and that they're allocated in a fair and transparent way. So where it used to be, I won't say how many years I'm going back, but when you used to work in hospitality, you'd have the tips in a jar and they'd be distributed every week or not, as the case may be. This is trying to bring it together so that all employees receive a fair share of what they're entitled to. So this is relevant where qualifying tips, gratuities and service charges are paid at or attributable to an employer's place of business more than occasional and exceptional basis. So, if it's a restaurant, you get tips, you get tips, it will fall under this provision. It is mandatory that you have a policy in place to cover it. This needs to be reviewed every 3 years. If you don't have a policy and you don't allocate the tips correctly, as of October 24 to April 25, you would be subject to a maximum award of £5,000, which has now gone up to £5,135. So realistically, if it applies to you, get a policy put in place, because it's not worth taking the risk for the £5,000 claim. And I think the tribunals will be quite stringent on this. I think they will take a dim view of anyone who doesn't operate fairly under the regulations. So the action that I've put there is to ensure a clear and transparent policy is in place with a trunk master. So if it applies to you, I am happy to run through, sorry, something's coming up on the corner of the screen to see if we've got any issues. I'm happy to go through the actual process, which is too detailed to go through at this point. But as I say, if it is applicable to you, do get in touch and I can help on that basis. Again, I am sure that you all are aware of the sexual harassment and prevention that was introduced on the 26th of October 2024. It has increased the requirements on employers to take reasonable steps to prevent sexual harassment of their employees during the course of their employment. Reading that, if you think about reasonable steps, it's pretty wide. It's a pretty wide statement. It includes anything by third parties and is going to be quite onerous for employers to try and justify if an act of sexual harassment occurs. You will face both financial penalty of an uplift to the employee's compensation and an potential investigation by the EHRC, which may result in enforcement action. Employers may wish to consider taking practical steps. Get your staff together, do a risk assessment, have policies in place, send out memos. We did put together a sexual harassment and prevention policy that basically will tick all the boxes. but it is going to be a tried and tested policy. Sorry, there was a question come in, just bear with me. Potentially, yes, on the tips question. Can I come back to you at the end of the webinar? And we'll have a conversation about that, because it can be quite complicated. So on the sexual harassment, I think if you have your policies in place, that will work. But I'm concerned really about the term reasonable steps. Again, until we have some sort of test case, which nobody wants to be, we won't know absolutely what is meant by reasonable steps. But I would suggest that initially, particularly managers, get them on training courses so that they are fully aware of the implications and what sexual harassment is, because that's not clear to all. So I would certainly start by getting those training courses in place, do some external training if necessary, because there will be quite a significant liability if it's not done correctly. And for any of you who work with third parties, which is probably quite a lot, it applies there as well. So the difficulty is you're trying to manage something that is potentially outside your control. So again, with third parties, make sure that they've signed off, that they understand your policies, for instance, if they're on a site that you manage. So, neonatal leave has been introduced. 1 week of neonatal care leave for each qualifying week their child spends in neonatal care, up to a maximum of 12 weeks. It's very similar to how you would do maternity leave, really. It must be taken in weekly blocks. Care must begin within 28 days of the child's birth and last for a continuous period of 7 days. The employee must have a qualifying parental or personal relationship with the child, and it's a day one right. The qualifying parental personal relationship, again, would be similar to the family-friendly policies that you would have in place anyway. Employees must comply with notice requirements, and they have the right to return to the same job, or in certain circumstances to return to a suitable and appropriate alternative job. So again, it's very similar to the provisions that override the family-friendly policies you will already have in place. What I would suggest, it's quite clear we will need a policy, because it's not, this is something that has just been introduced. So again, your policy is absolutely key. Statutory neonatal care pay, again, is very similar to the pay for your other family-friendly requirements. If as a business you offer enhanced paternity pay, maternity pay, you may offer enhanced statutory neonatal care pay. Such a mouthful. Again, you need to have that in your policy. The policy needs to specify the pay provisions. So the employee must have at least 26 weeks continuous service ending with the relevant week, must have received normal earnings for a period of 8 weeks. It's paid at the same rate of statutory paternity pay or shared parental pay, and it may be paid for a maximum of 12 weeks and payable within the first 68 weeks after the child's birth. Employees who are taking or have recently returned to work from neonatal care leave are entitled to be offered suitable alternative employment on redundancy and priority to other employees. So that's very much like the position in relation to maternity. Same thing applies. And as you are no doubt all aware, they're protected. It falls within one of your protected characteristics, and it's a protected detriment. So it would be potential automatic unfair dismissal if you were to dismiss someone for taking or applying for neonatal leave. So this is just a sort of cheat sheet, really, for you to have for your family-friendly leave. You'll see that, as we've discussed, they all sit at the same rate. And you'll notice at the bottom, we've got parental bereavement pay and statutory neonatal care pay. I wouldn't, if you are doing policies and procedures, I wouldn't insert anything that means you have to update it every year. So don't put any figures in, but just term it as, for instance, statutory paternity pay will be paid at the set, at the government set level every April, or 90% of your wages. So just try and term your policies so that no one wants to be updating a handbook every 12 months. So just cover it off as a government increase. Statutory sick pay, that's not family-friendly leave. So, I don't know why that's been thrown in there. You never know. You're probably all aware of the SSP change, day one entitlement, over and above the 3 waiting days now. Update your absence policy. If you pay company sick pay, again, you will need to update a policy to reflect that it is inclusive of SSP, which is a day one right. So any SSP is included within your company sick pay. So again, it's just another part of the handbook or your policies, however you word them, that needs to be updated. Statutory maternity and adoption pay, again, that's just for your reference. If you, just keep it as a cheat sheet, really. And as you know, every April, we also have an increase in tribunal rates. So obviously, I'm not going to go into how the tribunal operates, but there are 2 basic awards. There's a basic award and a compensatory award. The basic award, as I've put at the bottom, is a calculation, is the same as what any redundancy pay would be, which you can see. This has increased to 21,570, which is what the max on the redundancy would be. Unfair compensatory award. Compensation is related to loss of earnings. So the max award is £118,223. So if you're looking at a 12-month loss and it's somebody who earns over that, then obviously you are just going to hit the limit, if you like. So those are just 2 figures for your reference. I have to say it's very seldom that you will get a max compensatory award, but it is something to be mindful of. The main hit of awards, as you all know, is called injury to feelings. So if you have a discrimination claim against you, the claimant will be advised that as part of as a part of the additional claim, so you've got your basic, your compensatory, there is something called vento bands. These are where it basically is different rates of discrimination. So the lower band, the 1,200 to 12,000, is for basic one-off act of discrimination. So if we use sexual harassment, seeing as that's been in the headlines, if you like, one-off sexual harassment will fall within that band. The middle band is a series of discriminatory acts that fall into the more serious, but it's a series or one-off act that is really serious. So there would have to be quite a history of discrim to fall within the middle band. Top band, very seldom are they awarded, and that would be for a persistent, ongoing and serious discriminatory conduct by the employer. So those are your three bands, and it's always useful to be aware of those, because I'm finding more and more discrim claims coming in, and claimants will undoubtedly go for middle to top bands. So it just gives you some idea of where, when you're responding, how to kick back on that. And the grand finale, I'm not sure how grand it is, to be fair, but the Employment Rights Bill. So it's had so much press and caused a little bit of panic, I have to say. But as I said at the beginning, we've got time for the Employment Rights Bill. The things that we've been through so far, those are the things that are in effect. So we need to update policies on that. So you need to action those. The Employment Rights Bill, we've got time to prepare effectively. There's something called a Fair Work Agency, which is going to have various legal powers, and I have to say quite considerable legal powers of enforcement. So they will be the sort of overarching agency to monitor, manage and enforce against employers who don't comply. So if you are in breach of the Employment Rights Bill and any of the contents, the Fair Work Agency has the ability, or will have the ability, to issue notices of underpayment going back to 6 years and uprated to current rates. So going back 6 years used to be an exception rather than the rule, and going back 6 years, you used to go back on the rates that were applicable 6 years ago. That's not the case. So they will issue notices and you will pay at that year's rate for 6 years back. Issue penalty notices of 200% of the underpayment. 200%. Maximum of £20,000 per unpaid worker. It's just a lot for a single breach. So it just shows how careful we're going to need to be moving forward. The one that interested me, well, I say that loosely, is they will also have the power to bring employment tribunal proceedings or provide legal assistance to workers and recover costs from the losing side. So it's going to take, it's going to show a whole different proceedings, you know, whereas usually proceedings are the claimant will issue and you're fighting against them. We've now got a proposal that you've got people who will be qualified and will be able to assist employees. They will also have the power to recover enforcement costs for any defaulting employer. We don't know how that's going to sit yet. We're waiting for additional information to come through on the bill. So in practice, what we anticipate is that enforcement officers entering any premises shall have inspection powers and the ability to seize items where necessary. It's almost a Fair Work Agency bailiff, isn't it? Yes, it's going to be a significant change. However, it's thought to be taking between 18 months and 2 years to create this. So we have time. So what we need to do is make sure you're fully compliant with everything around holiday pay, national minimum wage, sick pay. So don't leave any stone unturned, I think is the point. Use, as I say on the slide, use the time wisely to get everything in place. So scaremongering over. Fire and rehire. Again, this caused a lot of stress, if I can say that. A new statutory code of practice, believe it or not, on fire and rehire, dismissal and re-engagement came into force in July 2024. So there was already a statutory code of practice in place, but this is going to be enhanced by the Employment Rights Bill. There will be a new automatically unfair reason for dismissal where the employer sought to vary the contract and the employee did not agree to the variation, and, not all, and is seeking to employ another person or re-engage the employee under a varied contract of employment to carry out substantially the same duties as the employee carried out before being dismissed. This applies to fire and rehire and fire and replace. So where we have had the ability to consult with employees, you need to make changes, business reasons require changes to be made. It's not a redundancy situation. You consult with the employee, you then terminate and re-engage on new terms and conditions if the consultation doesn't result in an agreement. That will not be possible. So you will need to look at recruitment in some detail. Job descriptions need to be updated so that you are clear if you do need to change any terms and conditions, that it is a provision within the contract that allows you to do so. However, it's not something that, whereas I would have advised previously that yes, do that, there's a significant business reason to do so, that won't apply moving forward. So how do we avoid that? So we've just had the bad news, we can't fire and rehire, etc. However, you can, if you're able to satisfy a tribunal, because if it gets that far, of 2 narrowly drafted conditions. That the reason for the proposed variation was to eliminate, prevent, or significantly reduce or mitigate the effect of any financial difficulties which at the time of the dismissal were affecting or likely to affect the immediate future, the employer's ability to carry out the business as a going concern or otherwise to carry on activities constituting the business. So basically, if it's a financial reason and it goes to the heart of the business, so it can affect the fact that you cannot continue operating. But you'll notice that there's an and, there's not an or, so it's not either or. It's an and, that in all the circumstances, the employer could not reasonably have avoided the need to make the variation. It's quite tight, isn't it? It's not something that they've drafted it in that way so that, yes, it can be avoided, but actually it's going to be pretty difficult to do so. So both of those conditions need to be satisfied. The tribunal will then obviously go on to consider whether the fairness of the dismissal. And as we all know, the Birchill British Home Stores case on the test of reasonableness in relation to process and the termination. So it is going to be not as simple as it has been. And, you know, for many reasons, businesses need to have the ability to vary a contract. So again, need to be mindful of the reasoning, but keep in your mind that there are reasons, but you need to fall within those two circumstances. And now we have the most radical change to unfair dismissal in over 50 years. And we've all heard it, haven't we? It's been out there. The right not to be unfairly dismissed will become a day one right. Without giving away too much on the age front, I remember when it was 1 year and then they upped it to 2, and that was great. Unfortunately, it's a complete U-turn now, and it's a day one right. So the Employment Rights Bill, how it achieves this is by changing the Employment Rights Act of 1996 to remove the current requirement that employees must have 2 years service. So it's that simple. All they've done is amended it, referred to the ERA of 1996, and removed the 2-year service. So what do we do? Well, the bill refers to dismissal during initial period of employment, sometimes referred to as the statutory probationary period, for the potentially fair reason of capability, conduct, illegality, or some other substantial reason, but limited to reasons related to the employee. So that basically means that during the initial period of employment, so what we see as the probationary, I'm sure most of you have 3, 6, 9-month probationary periods within the contract. Historically, we've always thought, well, that doesn't really matter apart from notice, because we only give a week's notice during probationary or a month, and thereafter it increases. So that was the only real reason for the probationary period to be in place. However, clearly that's going to be really significant moving forward. So you will need to have an initial period of employment. So I would amend your contracts to say actually that you might as well just put the wording directly in. You know, your initial period of employment will be X. During this period of time, we reserve the right to, you know, manage your performance, discuss with you, etc., etc. So just expand on your probationary period clause. And you'll note at the bottom, I said the fact that redundancy is not included means employees will be entitled to claim unfair dismissal in relation to redundancy from day one. So redundancy doesn't fall within the initial period of employment. So that is a key difference. So what is initial period of employment? It's the legal definition will be between 3 and 9 months. Can you extend the probationary period from that to then make sure that there's no automatic right? I don't think that's going to be the case, because otherwise it would be nonsensical to have a time limit in place if we were able to continue to extend the probationary period to avoid the day one right. So I think you're going to have to go with 3 to 9 months. 9 months is going to be adopted by most employers, I would suggest. Any process an employer must follow in order to justify a fair dismissal during this initial period will be determined by regulations made by the Secretary of State. We don't know what they are yet, which is really helpful. It's expected that a lighter touch process will apply during the initial period. So during the initial period, they will take a more broad approach to any termination. But again, as I said at the beginning, we're not sure yet. We need to wait for further guidance. Further government amendments have suggested that the Secretary of State will have the power to cap compensatory award for employees who are unfairly dismissed during the initial period. So that basically is, you know, we're giving all employees day one rights. However, if they are successful at tribunal, that any compensatory award will be reflected to show that they'd only been with you for 3 months. In essence, that's what that is hoping to achieve. But again, I apologise for not being able to sort of throw lots of examples out, but these are all going to be tested points once we get the bill in full. And if anyone's decided to go and have a look and read it, no, absolute, well, it's pure insomnia, but you know, it's hefty. So withdrawing an offer. Initially, we all thought that could fall under the day one right. As you know, there's still claim for discrimination, etc., if we withdraw an offer for any protected characteristic. The right to claim unfair dismissal will not apply to dismissals occurring before employee has started work. So that's a bit of a sigh of relief. But this is unless the offer was withdrawn due to specified reasons, which are the usual automatically unfair reasons, which I'm sure you're all fully aware of, and any discriminatory. But it also includes job offers withdrawn due to an employee's spent convictions, political opinions or affiliation, and membership of armed reserve force. I've never actually come across a claim for an armed reserve force, and I got ahead of myself there. So yeah, that hasn't changed. And what I would suggest is just look at your recruitment anyway, because I think it is important that when offers of employment are made, you maintain a paper trail. So what does this mean for you as an employer? Many changes in the pipeline. I've called this the best bits, but that's open to dispute. So what do we need to do? Well, you need to go back to the beginning, the first slide, and make sure that the policies that you have in place reflect changes that have already been made. In relation to preparation for the changes that are forthcoming, take steps to enhance your recruitment procedures and pre-employment vetting. It's, you know, we all ask for references, but we don't tend to do much more as part of a vetting process. But you will need, well, you need to get the right people in. So you do need to get those recruitment policies up to speed, because you can't afford as much as previously to have the wrong person in the wrong role. You then need to strengthen the procedures for assessing performance of new hires during probationary period, initial period of employment. So make sure you have a regular meetings. Usually it's, so they've come to the probationary period, we'll have a meeting, oh, they've passed or not. That's not going to be possible now. So you can't have the situation where Fred has been a bit rubbish throughout his probationary period, but we've done nothing about it because he's all right. So we've just extended his probation and we've still done nothing about it. He's then sacked, he makes a claim, His claim goes back to day one. His argument will be, well, they never told me I was doing anything wrong. Nobody picked it up with me, so I just carried on as normal. So you do need to look at your handbook and make sure there is a process of performance review effectively. Poor old Fred. So harping on, aren't I, about these policies? But if you think back to the initial slide where we said about the Fair Work Agency, sorry, this question come through and I can't see it. Bear with me a second. Again, we're not, so we've had a question, will the unfair dismissal right from day one be applicable to everyone who is already in the business from the effective date of the change, or only to employers who will be hired after that date? So to summarise, whether it's a retrospective right, I would anticipate it's for those who are employed from that date, because you can't go back, can you? I mean, it would make it almost impossible for you to manage if it went back to everybody who was employed in the business. So it's going to become a day one right as of that point, much like you get a flexible working right from day one at that date. I will have a look to see if there's anything that specifically applies to that, but as far as I'm aware, it's a day one right from when it is in place, which again, I can have a chat with you after this if there's something that we can run through. But again, it says that this changes are not enforceable until, I think it's going to be next year. It's not going to come in. I think we all panicked, thinking that it was going to be now. But we've got time to prepare. And again, that's the point, isn't it? Let's prepare for these things. What you need to do now is review your current policies and procedures to ensure best practice and legal compliance. Again, go back to that Fair Work Agency. They will be almost they will be the enforcer. Sound like a person, but they will be the enforcer. So you don't want to fall foul of that. It's not worth it. You might as well just get everything in place in advance. I would suggest you make preparations for all the changes, significantly looking at your recruitment procedure. The recruitment procedure is key, because if you get the right person at the beginning, then we're okay. Contracts of employment, get those updated to reflect, as I say, initial period of employment. There's no harm in doing that now. It's a fairly minimal change, and you can justify the change because it's going to be a legal update. It's a legal requirement, much like when we had to change holidays, etc. So yes, a lot still to be decided, as I think we're all aware of, because I can't give any specific answers to some questions, because we really don't know until we get more idea from the government. So the idea for us is that we are going to start continuing webinars as soon as we get any updates. These are the proposals you need to be aware of. There are lots and lots and lots of other proposals within the Act, which, some apply to TUPE, collective redundancies, all of which are going to come to the fore in the next few months. I would say by the end of this year, I'm hoping we will have a lot more to talk about. But it's, you know, it needs actioning. And what I've said here is do some critical decisions that need to be taken within the next 12 months before restrictions of fire and rehire come into effect. Basically, what I'm saying there is review the workforce, have a look at where you're sitting, who's performing, who isn't, get your critical business reasons in place and action them now rather than waiting. How will your recruitment and retention strategies change in light of the increase in the protection against unfair dismissal? It's going to have to change because you are going to find a lot more claims coming through. And employees don't have to pay either. So, you know, there's no fees for them. So unfortunately, it's the employer who's carrying the can. So do these critical business decisions now. For some reason, I've given you the tribunal rates again. Quite useful. So that comes to the end of a flying whistle-stop tour of the Employment Rights Bill. If anyone has any questions or concerns, please give me a call. My email address is on the screen. I do believe that Saul will be sending out a recording or slides. He'll probably tell me in a minute or not. Yeah, so I think Saul will be sending, yes, there will be a follow-up. So Saul will be sending out any necessary feedback, questions, etc. So has anyone got anything they want to raise? There are a couple there that I said I would get back to. But if anyone, as I say, if anyone's got any issues, just give me a call. We do have, as I say, as part of the service, we do update all your documents, policies, procedures, and contracts. So, you know, if you're interested, give me a shout. If you're interested in reading the Employment Rights Bill, good luck. I'm sure you'll have a smashing time. I'm only halfway through, but there we are. So if that's everybody and nobody's got any questions, I'd like to thank you all for attending, and anything else you need, please let me know. Thank you.